Hello, my name is Jeff Boltwinder. I'm a lawyer in Southern California. Thank you for attending this legal education course. Our topic is insurance law, specifically the rules relating to liability insurance. This CLE is designed primarily to teach the basic fundamentals of analyzing a liability insurance policy. So roll up your sleeves. We're going to crack open an insurance policy, and hopefully, I'm going to demystify the process of performing a basic coverage review. All right. Now, today's focus is the contractual duty of a liability insurance company to furnish a lawyer when its policyholder has been served with a lawsuit. By policyholder, I'm referring to the named insured or anyone else who qualifies as an insured under a liability policy. So what we're talking about today is the duty to defend, the right to be lawyered up, if you will. A denial of coverage can have truly devastating consequences to a policyholder, whether it's a business or an individual, both emotionally and financially. Fortunately, many disclaimers can be successfully challenged, and this is because California law tilts decidedly in favor of policyholders on the duty to defend. So today I'm going to discuss the process of reviewing a liability policy, evaluating the merits of a denial of coverage, and potentially mounting a challenge to the insurance company's denial of coverage. All right, this is a workshop format today, and it consists of a skills component in lesson 1 and a substantive law component in lesson 2. In lesson 3, I want to turn to exclusions and how to evaluate insurance company disclaimers for the purposes of possibly challenging the insurance company's coverage position. In lesson 4, I will switch from the duty to defend to the contractual right of the insurance company to defend. And that includes a brief discussion of the tripartite relationship, the insurance company's control over the litigation, and conflicts of interest. Finally, in lesson 5, I want to address the very important issue of remedies. And there, I want to spend a few moments explaining the unique challenges in making a policyholder whole when the insurance company has refused to defend the insured. All right, so let's begin lesson 1. This is our skills component. When an insurance claim is denied, the insurance company is required to write a disclaimer letter explaining the basis for its coverage decision. I've drafted many such letters. For nearly 20 years, I represented insurance carriers as both an insurance analyst and a litigator. I now represent policyholders exclusively. And when we are consulted, our first step is almost always going to be to outline the facts and the policy language in the disclaimer letter that purport to support the denial of coverage. Using those grounds as a starting point, we then perform a policy analysis to evaluate whether our conclusions differ from those in the disclaimer. All right, now we are ready to crack open an insurance policy. Now, everyone knows that insurance policies are not fun to read. They're dense and filled with fine print. How does one take a stack of policy documents and drill down to the core components. Well, I want to go over three different things here. First, it is important to understand how to organize the policy documents for review, how to sort out what the contract consists of and what's important and what's not. That's C for contract. Second, it's important to understand how to isolate the critical policy language that's in dispute. And this involves an understanding of the four major policy provisions in the policy. Third, and that's A for analysis. And finally, it's necessary to understand how to analyze the disputed policy language and evaluate it based upon the correct legal standard. And that's R for rules of interpretation or rules of the road. So remember the acronym CAR, and I'm going to go into each one of these in a little bit more detail. The first step is C for the contract. What does the contract consist of? Well, the declaration pages are the natural first step in performing a coverage review. Many of the forms and endorsements in the policy are going to refer back to information in the declaration pages. So a review of a policy is necessarily incomplete if you're not looking at the forms and the declarations in conjunction with one another. Now, effective dates are particularly important in any coverage analysis under really any type of insurance product. And that is because virtually every insurance policy ever written, the benefits will be triggered by certain specified events taking place within the coverage period. Now, modern insurance products consist of many, many forms, and that's especially true with commercial property and commercial liability policy packages. Don't be intimidated by all the forms, because most of these can be ruled out very quickly. What you need to do is locate the schedule of forms and then study it closely and find coverage related forms and any amendments to that. Now, a very common form of liability insurance in the United States is a commercial general liability policy, often called a CGL policy. Many businesses in the United States, large and small, have this identical form of coverage. On the screen, you'll see a 2013 version of the CGL form, but this basic form has been around since the mid-1980s. Once you find the coverage form, head straight to the insuring agreement, which is where you will find the insurance company's expression of its promise to extend insurance protection if an insured event takes place. Now, the way modern insurance products are structured is that underwriters draft a broad insuring agreement that embraces an entire class of insurable risk. The coverage is then narrowed and tailored to the specific underlying underwriting intent through the use of multiple exclusions. And those appear later in the policy. We'll get to exclusions in a few minutes. Now, the first sentence that you're looking at is what's known as the indemnity benefit. Now, let me back up a little bit here. A CGL policy, like any liability insurance, homeowners, auto, whatever, affords two primary insurance benefits: the indemnity benefit and the defense benefit. So we're going to talk about the indemnity benefit briefly here before we get to the other benefits of the policy. The first sentence is the promise to indemnify the policyholder, the insured, and this means that if the insured is held liable, the insurance company will pay the third-party plaintiff the amount of the judgment. That promise is limited under a CGL form to compensatory money damages because of property damage or bodily injury. Now, let's look at the second sentence. This is the defense benefit. That promise is limited to lawsuits seeking damages that are potentially within the scope of the indemnity benefit. So in the first two sentences of this insurance agreement, we have two promises, two duties, two benefits, both equally important, related, but separate and distinct in purpose and in scope and in their respective triggers. The highlighted sentence is the focus of today's discussion. That's the duty to defend, the promise to furnish a lawyer to represent the policyholder in the defense of lawsuits seeking monetary damages because of defined losses. All right, that's our first step, C for contract. We've got our arms around the contract, so let's go to A for analysis. Now, how do you know which part of the coverage form to read and analyze? Well, the disclaimer letter is the starting point for sure. And in most cases, that's probably as far as you need to go, because those will cite or quote the policy language that's going to be in dispute. But it's also important as a coverage analyst to be able to spot the issues and to understand the four major types of policy provisions. So I'm going to go through here very quickly and go through the four major issue groups in the natural sequence that you would want to analyze. The first issue group deals with policy provisions that describe who qualifies as an insured. Now, only those who qualify as an insured are entitled to policy benefits such as a legal defense. If the person seeking the defense qualifies as an insured, the coverage analysis naturally proceeds to the second major issue group, and that's the insurance agreement. We just looked at one. It has several elements. If the lawsuit seeks damages falling within the insurance agreement, the analysis then turns to exclusions. And as we'll see a little later on, exclusions are policy provisions that take away coverage for claims that fell initially within the insurance agreement. If no exclusions apply, the insurance carrier must immediately defend because there is a potentially covered lawsuit that's been filed against the policyholder. Now, the last issue group is conditions. Breach of conditions by a policyholder is ordinarily not going to excuse the insurance company from performing its obligation to defend, but sometimes it does. And the issue group here of conditions refers to policy provisions that impose a duty upon the policyholder to do a thing or refrain from doing something as a condition of coverage. That's A for analysis. That's the second of our three steps here. We are now at R for rules of interpretation, or I like to think of it as rules of the road. Insurance companies are permitted by law to choose the language they put into their policies. In fact, the Supreme Court has more or less said that, subject to certain regulations and so forth. But insurance companies cannot arbitrarily choose their preferred interpretation when a claim arises. They're not allowed to make promises and then decide how they want to interpret it when it comes time to pay a claim. Rather, the insurance companies must interpret the policy and perform pursuant to that interpretation based upon the correct legal standard. Okay, so let's talk about those briefly. The general rule is that insurance policies are contracts of insurance, and the usual rules of contract interpretation are going to apply. And so the general rule here is that language will be usually interpreted based upon its plain meaning within the confines of the four corners of the contract of insurance. Now, language will not be enforced, however, if it is not plain, clear, or conspicuously placed in the policy. If policy language is ambiguous, courts will usually find in favor of the policyholder, but not every time. A court, however, is not going to find an ambiguity unless the key language in dispute and viewed in context with the entire policy is subject to multiple interpretations, and those multiple interpretations are reasonable interpretations. And under one of those, there is no coverage, and under one interpretation, there is coverage. That's a true ambiguity. Now, one final comment before we close out the rules of interpretation here. It is very fair to say that California case law as a whole reflects a general pro-coverage slant, especially on the duty to defend. And there is black letter law that insuring agreements should be interpreted broadly, and restrictive or exclusionary language should be interpreted narrowly. All right, that brings us to the end of lesson 1. Before we move to lesson 2, let me just summarize lesson 1. First, C for contract. We want to sort out the relevant policy documents. A for analysis. We want to isolate the key language in dispute. And third, R for rules of interpretation. Evaluate whether the coverage position in the disclaimer letter is consistent with the relevant legal standard. Now that we've completed the skills component, let's look at the substantive law. If you mention the words liability insurance, most people will not think about the duty to defend. People tend to think about liability insurance in terms of the type of policy and the amount of policy limits available. Now, the dollar limit of a policy is a feature of the indemnity benefit. But the insurance protection afforded by the defense benefit is unquestionably of equal importance. And in many situations, it's far more important than the indemnity benefit. Since at least the 1960s, the California Supreme Court has recognized that liability insurance carriers owe a very, very broad duty to defend. And then more modernly, beginning in the early 1990s, um, the California Supreme Court issued a number of opinions over the ensuing years in which it confirmed its historic, expansive view of the duty to defend, and even went further than it had before. The court seemed to go out of its way to draw a very sharp distinction between the very narrow duty to indemnify and the far, far broader duty to defend. The court characterized the contractual obligation to defend as a service, that's a quote, to avoid or minimize the policyholder's liability, and that defense obligation may arise as soon as damages are sought. As soon as damages are sought. In my judgment, the Supreme Court was sending a clear message to lower courts and insurance companies. And that is that the entitlement to a defense is vitally important to policyholders, and that defense obligation attaches immediately and completely. Now, let's talk about the temporal scope of the duty to defend. Let's talk about when the duty to defend starts and stops. Under a general liability policy, the duty to defend arises as soon as a lawsuit is tendered to the insurance company, and that lawsuit seeks damages that are potentially covered under the policy. Now, some liability policies may apply to pre-suit claims, but a CGL policy and many other types of policies only apply to lawsuits. So a pre-suit claim and fees incurred during that time period are not going to be recoverable in most situations. Now, even though a CGL policy only applies to lawsuits, the mere fact of a filing of a lawsuit is alone not sufficient to trigger the duty to defend. The insurance company is going to need notice, either actual or constructive notice of the lawsuit in order to activate its duty to defend. Once the duty to defend attaches, it endures until the very end of the case, or until the insurer can prove conclusively that no potentially covered claims remain in the lawsuit. Now let's switch from the temporal scope of the duty to defend to the substantive scope. Let's look at hypothetical number 1. Poor Rachel is facing liability on 5 counts, and only 2 are potentially covered: libel, slander. This is called a mixed action. Now, Rachel's insurer contends that its policy only requires a defense to the 2 potentially covered claims. Rachel believes a full defense is owed under the policy's terms. Who's right? Well, Rachel is going to win the argument, even though both she and the insurance company are a little incorrect in their arguments. Under the bus case, a court would agree with the insurer that its contractual duty is limited to only the 2 potentially covered claims. However, in the bus case, the court reasoned that an insurer cannot meaningfully defend less than an entire lawsuit. So the court essentially concluded that in a mixed action, the duty to defend extends beyond its contractual scope by operation of law. So Rachel will be fully protected during the pendency of the lawsuit. She's actually getting more defense than she paid for. And the California Supreme Court acknowledged that. It also reasoned that because Rachel is basically being unjustly enriched under these circumstances, her insurer possesses a quasi-contractual right to seek reimbursement. And that is the state of law in California. So here, the insurer would need to provide a complete defense to Rachel, and it would also be reserving its rights to deny coverage for the 3 uncovered claims. And if it chose to do so, it could also reserve its rights to seek reimbursement for any fees and litigation expenses that were incurred in the defense of claims that were not potentially covered. That's the bus case. That completes lesson 2. In lesson 1, we sharpened our contract analysis skills. In lesson 2, we learned about the policyholder's right to be lawyered up. Let's turn to lesson 3 and look at exclusions and how to challenge a denial of coverage. Okay, so when an insurance company receives a claim, it's going to open up a claims file, assign a claim number, and assign an adjuster. And one of that adjuster's first steps is going to be to perform a coverage review. So the adjuster will first determine if the party who has tendered the claim, does that party qualify as an insured? And if so, do the claims fall within the insurance agreement, at least potentially? If the answer is yes and yes, the adjuster is then going to turn to exclusions. And there's always very many exclusions in liability policies. And in fact, insurance adjusters, when they deny claims, exclusions are probably the basis for the disclaimer 50 to 60% of the time, at least. Now, under California law, the insurance company bears the burden to conclusively show that the exclusion eliminates the potential for coverage in the lawsuit under any theory of liability, all claims, all damages, all theories. This is a very high threshold. Now, in my opinion, in my experience, insurance companies often cite exclusions prematurely. And why do I say that? Many exclusions will apply, if at all, only to the duty to indemnify and only after liability and damages have been proven. At the outset, the insurance companies are not permitted to adopt unwarranted factual assumptions about what might happen in order to invoke an exclusion and avoid jumping into the defense. Now, in hypothetical number 2, a scenario that I've seen many times, an incident took place between Diane and the bouncer, and maybe Sam, we don't know. So she sues both of them. They file an answer, and they generally deny all allegations, as one can do in state court. They tender to the insurance company, and Sam's insurer refuses to defend either Sam or the bouncer. And the basis for that is an intentional act exclusion. Now, all liability policies have intentional act exclusions, among others. and there's even a statutory exclusion in California. And so I want to take a look at that while we're looking at this hypothetical. Now, with any exclusion, the most important thing to do first is to very carefully study its language. So let's do that here. I'm going to read the first clause, and this is statutory language. An insurer is not liable for a loss caused by the willful act of the insured. That is not a typo, by the way. That is the actual spelling in the statute. An insurer is not liable for a loss caused by the willful act of the insured. So what does this language tell us? What does this exclusionary language tell us? Well, first of all, you want to find the focal point of the analysis. And here, that is in the words, the willful act of the insured. So the analytical focus here is intent. That's number one. Second, the language here requires a separate analysis of Sam and the bouncer. Now, why do I say that? It says the willful act of the insured. Well, that language has been interpreted to mean each particular tendering party seeking coverage. So we're going to have to perform a separate analysis as to Sam as opposed to the bouncer. All right. Now, let's look at the first few words here. A loss caused by the willful act of the insured. Now, clearly, under this language, the insurance company is not going to be liable for losses caused by the willful act. It's not going to be obligated under the indemnity benefit, but there is nothing in this language that is specifically excluding a defense to claims about a loss caused by the willful act of the insured. So this language does not support specifically a denial of the duty to defend. All right. Now, fourth, the final clause here, the insurer is not exonerated by the negligence of the insured or its agents. So the second clause is an exception, a very broad exception for negligence liability. So let's now look at this analysis. Here, Sam's direct tort liability, other than vicarious liability if he's the bouncer's employer, could be limited under these sparse facts to negligent hiring or negligent supervision, not actual intent to harm. Under these facts, we don't even know if Sam was at the bar at the time of the incident. And the bouncer, like Sam, has denied all allegations, and by doing so has placed at issue all facts alleged in the complaint. In fact, under these facts, no one has even admitted that an incident took place, much less that Diane will be able to prove willful torts that cause her a loss. So under these facts, the only basis the insurance carrier has is Diana's pleadings, and that's not going to be enough to avoid the potential for coverage. The insurance company has to defend here, and if it wants to preserve its rights to deny coverage down the road, it's going to have to reserve its rights on the intent versus neglect issue. And in the next chapter, we'll see the implications of that on the insurance company's right to control the defense. Now, before we go to lesson 4, let me round out lesson 3 with some general comments. We only looked at one exclusion. Policies contain many exclusions. I want to provide you with a generalized approach for handling all exclusions. First, you want to carefully consider, carefully study rather, the text of the exclusion and find its core criteria, such as intent. Second, think about and consider the type of evidence or information that would be needed to invoke the exclusion. All right. Now, remember when you're doing this analysis to uh, uh, think about, remember that the duty to defend is determined at the outset of the case and based upon the mere potential for coverage. So ask yourself, what evidence would the company need at the outset of the case to invoke this exclusion? And was that available to the insurance company when they issued a disclaimer letter? And that analysis may lead you to the conclusion that the insurance adjuster has made unwarranted assumptions about facts in order to avoid a defense. All right. So in lessons 3, we addressed the contractual duty to defend and the policyholder's corresponding right to an immediate defense. Let's now look at the right to defend and conflicts of interest. Now, when an insurance company agrees to defend, they customarily will select and retain an outside law firm and lawyer to defend the policyholder. These firms are sometimes referred to as insurance defense firms. These firms are on the panel of the insurance company's outside attorneys, so they're sometimes called panel counsel. Now, this creates a three-way arrangement known as the tripartite relationship. The insurance company pays the defense counsel to defend the insured defendant. The defense counsel's primary duties are owed to the policyholder, but under California law, both the insurer and the policyholder are considered to be clients. Now, the tripartite relationship functions effectively in the absolute vast majority of lawsuits, undoubtedly. But joint representation occasionally gives rise to a conflict of interest on the part of the insurance company with respect to its preferred counsel. So let's take a brief look at the history of this area of law before we summarize the current state of the law. In the 1960s and 70s, as the tripartite relationship was relatively new, a few courts began observing that joint representation occasionally may function to prejudice the policyholder when one attorney is representing both the policyholder and the insurance company. In the executive aviation case, a mysterious plane crash took place and litigation ensued. An issue arose in the litigation concerning which standard of care would apply in the case. And that liability issue hinged on a factual issue in the case. And that factual issue was this mysterious flight, was it a sales demonstration flight or was it a common carriage flight? And that issue in the litigation was intertwined with a coverage issue. Now, as it turned out, under the very peculiar facts of the case, the policyholder's defense counsel was also the insurance company's coverage counsel, something that you would never see these days, but it was a peculiar case. At any rate, the Court of Appeal, the issues ultimately came to the attention of the Court of Appeal, and the court expressed concern about the risk to policyholders in joint representation situations. And I think the court was primarily concerned that policyholders were not being fully informed and advised about the implications of joint representation early in the case. I believe that cases such as this ultimately led to the now very common custom of insurance companies issuing reservation of rights letters if there's any dispute regarding coverage at the outset of the case. In any event, the Executive Aviation Court was one of the first courts to recognize that occasionally an insurance company must surrender its control of the defense and pay the policyholder's preferred counsel to defend when it agrees to defend under a reservation of rights. Now, fast forward a decade or more to the famous Kumis case, and the conflict of interest issue arose again. And like the Executive Aviation Court, the Kumis Court seemed concerned about the institutional relationships between insurance company adjusters and outside insurance defense firms. Now, the facts of the Kumis opinion have really been eclipsed by the rule that's derived from its holding. It's actually been superseded by statute. And the facts have really been eclipsed by the fundamental factual paradigm that the Kumis case represents. So let me talk about that for a minute. The classic Kumis paradigm is a situation in which coverage hinges upon a disputed and malleable factual issue in the litigation. It hinges upon a disputed factual issue in the litigation, and the issue is one that is malleable, and specifically whether or not the insured defendant's liability is based upon negligence or intent, covered versus non-covered. That basic paradigm, intent versus neglect, is the prime example of what has come to be known as a steerable issue. A steerable issue is one that can be steered away from coverage by the manner in which defense counsel litigates the case. Now, there is a lot of literature and commentary that the holding in the Kumis case was overly broad, and that's probably an understatement. And I understand that in the years immediately after the Kumis case, policyholders and their attorneys demanded Kumis counsel whenever an insurance company reserved its rights. And I understand anecdotally that it was a bit of a mess. I became a lawyer about 10 years after the Kumis opinion. At any rate, because of the aftermath of the Kumis case and the arguably overbroad holding in that case, the legislature and various interest groups negotiated and codified the basic Kumis rule just a few years later. And that is Section 2860 of the California Civil Code. Now, Section 2860 was very ambitious, very forward-thinking, in my opinion. At any rate, it codified the basic Kumis rule, and it clarified and limited the basic holding in Kumis concerning when a disqualifying conflict arises. We'll see that in a few minutes here. Now, it also gave insurance companies important rights, and it also protected the policyholder here, okay? So, for example, insurers are permitted to limit the rates that they pay to independent counsel based upon a statutory standard. And if there are disputes regarding fees, certain types of disputes are subject to mandatory arbitration. Now, there's other protections for insurance companies. They're allowed to demand E&O coverage and minimal qualifications, and there are various other provisions that address information sharing and protections for privileged material. By and large, in my judgment, 2860 has worked rather well. Let's look at a couple of hypotheticals. In hypothetical number 3, Lucy has filed suit against Desi and alleged a variety of torts. And Desi's insurance company has agreed to defend, but reserved rights on all issues. Now, you can assume for the sake of this hypothetical that the insurance company has reserved rights on issues that are traditionally deemed to be steerable issues, malleable issues like intent versus neglect, factual issues that are subject to manipulation and where the defense counsel can massage the case away from coverage. Okay, so you can assume that we have those types of issues in this hypothetical. Nonetheless, the insurance company denies the demand for independent counsel. So who's right here? And the answer is that the insurance company is, under these facts, is probably going to be right at this particular moment early in the case. Now, why is that? Well, when the legislature codified the Coombs rule, it made the rule permissive, not mandatory. So let's look at the rule. It states when an insurer reserves its rights on a given issue and the outcome can be controlled by counsel first retained by the insurer, a conflict may exist. So the legislature clearly intended not to be very clear and clearly intended not to draw a bright line rule, but instead appears to have specifically drawn a very blurry line. So we must assume that the legislature intended what it was doing, and I think that's fair to say. Now, interpretive case law has held that under 2860, establishing entitlement independent counsel is going to involve more than simply pointing towards a reservation of rights letter and saying that there's a conflict because of something that the insurance company has said. Rather, the policyholder, at least under a strict reading of the statute and the interpretive case law, the policyholder is going to have to point to a conflict that is actual and significant, not merely potential and theoretical. In other words, even when the basic Coombs rule would appear to apply, a disqualifying conflict of interest does not necessarily arise under the codified rule. So here, Desi has not shown that there's a real, actual conflict. There may be, but Desi, under these facts, has not shown this. So this statutory language and the case law that I've alluded to, including the dynamic concepts case, is very favorable to insurers on the Coombs counsel issue. Let's look at one more hypothetical. That's number 4. Now, here, Archie was driving Edith's car and is involved in an accident. The pedestrian sues Archie and Edith. Edith's insurer agrees to defend both Archie and Edith, but it reserves rights on an exclusion. And that exclusion basically says if Archie was living with Edith at the time, he wasn't an insured because he's unscheduled. Now, they demand independent counsel, and the insurance company refuses their demand. Who wins and who loses? Well, the insurance company is going to win this argument almost for sure. And that is primarily because the coverage issue is extrinsic to any of the material issues in dispute in the litigation. In the litigation, the fact that Archie is living with Edith really has not much to do. It's not a material issue in the case, might be tangentially relevant to something, but it's not something that's reasonably in dispute. It's more of an objective fact. It's not a malleable fact. Okay. So because that fact does not appear to be a material, heavily disputed issue in the litigation, it's extrinsic. So the analogy to the Kumis paradigm, it fails. There is no coverage shifting like neglect versus intent. So under these facts, there's going to be no entitlement to independent counsel by virtue of the reservation of rights. Now we're coming to the end of our time, and I don't have enough time to go through the proper analysis of how to identify a conflict of interest. But in this slide and the next one, I've set forth some bullet points that will definitely help in the analysis of whether or not a conflict of interest arises when the insurance company reserves rights, or one of the other rare types of situations that may trigger entitlement to independent counsel. All right, now we are at lesson 5, remedies for breach of the defense obligation. This seminar really doesn't directly involve remedies. It involves the right and the duty to defend. But what are the reasons why the duty to defend is so unique and so special and so broad, according to the California Supreme Court, is because the breach of the duty to defend can be so devastating to the policyholder. The policyholder has a million things going on in their life, and now they got a lawsuit, and the insurance company says no, and they're now faced with an uninsured potential liability, plus defense costs and attorney fees for the next 2 or 3 years. So how do you go about making a policyholder whole when the insurance company has refused to defend? So I would ask you to consider it by the following metaphor. If litigation is a boxing match, okay, and if the plaintiff and the defendant are the boxers in the ring, pounding away at each other, what is the impact on the match when one party does not have someone in his or her corner between rounds? How would the match go differently? What is the value of the advice in between rounds? How would the case have gone better? How would the match have gone better or worse, depending upon if you had someone in your corner giving you advice between rounds, mopping your brow, telling you when to go in on the defense, telling you when to go on the attack, telling you maybe when to throw in the towel? The answer is you don't know. You don't know because you never know how things would be different. Okay. And